study that. I'll give you a chance. Thank you very much. I'm just wondering if the best way to begin is to permit each of the panelists to have a word in relation to the other papers that you've heard and any disagreements that you have seen in the other presentations. Justice Wilson, would you like to comment on anything that either of your successors on this podium said today?
Well, I would just like to say that I feel rather badly that I preempted some of the areas that Mr. Justice Krever had planned to speak about this morning, and I look forward with great interest to read what he has to say on the rather controversial subject of concurrent liability. Maybe we could have really battled it out right here.
Maybe we should, Justice Krever. Do you want to engage this sturdy Supreme Court justice in battle?
Well, the paper, when it's read, will, I think, disclose an attempt to try to be neutral on the subject and respect the views of the participants in the debate. But I think it's probably fair to say that it shows a preference for the concurrency theory rather than the contract theory of liability of lawyers.
There really isn't much disagreement up here today, because yesterday we were into this. Jerry Friedman of Western and he was advancing the purist theory, and I was advancing the confusion theory or the concurrent theory. But did you want to comment on this question? I think you had some material in your paper on this as well, which is a topic that is concerning us all and really does need more resolution. Do you want to be a little braver than the rest of us? Okay, we have 3 or 4 written questions. If any of you have any more, you can just produce them, and we'll of course be open to oral questions as well. I wonder, Bertha, do you want to try? Have you had a chance to look at any of these yet? They're quite complicated, actually. And
I had a look at this first question. It reads as follows: can the duty of an architect in tort extend beyond the duties undertaken by the architect to his client? Then it sets out a set of assumed facts. An architect contracts with the owner to design a building, but not to supervise construction. The architect knows that the owner is unable to properly supervise construction, but the owner does not want to pay the architect for supervision and therefore hires him for design only. In an action by a third party for damages arising out of faulty construction, can the architect be held liable? Well, of course, this really raises head-on what we have been discussing as to whether or not the person who has a contract should be allowed to say that the scope of his duties and therefore the extent of his liability should be circumscribed by contract, as opposed to being vulnerable to the imposition by operation of law of the wider duties owed in tort. And as you know, at the time that I sat on the cases I sat on the Ontario Court of Appeal, I certainly was of the view that in this particular area, the parties ought to be permitted to make their own rules governing the scope of their duties and the extent of their liability. That seemed to me at the time to be sort of a rather fundamental aspect of freedom of contract. But as we're all aware, there have been substantial developments since then, and I think that it's fair to say that the weight of authority perhaps is going against that now. And this is why I say it will be very interesting if we get a really good case that comes up to Ottawa to compel the court to make a definitive statement in this area so that people will know what they're doing, know the extent of their potential liability, and be able to protect themselves against it. But I really couldn't hazard. I would just be speculating if I tried to say what position they might take, because I think that even those who favored the strict contract position, like Chief Justice Laskin, may no longer do so. I think we have to wait for the right case, and then I guess we'll have to make our minds up and put this one finally to bed.
Do either of you gentlemen want to comment further on that?
I certainly agree with the attorney.
You two think the Supreme Court ought to resolve this thing? It was quite remarkable to see Bertha saying, and still saying, we've got to deal with this, and I expect it will be dealt with fairly soon. Do you want to deal with this one, Horace? Have you had a chance to look at it?
Yes, I have. It's this. In the Ferguson case, that's the case that Mr. Wortzman referred to this morning, on the issue of informed consent, would it have affected your decision if the plaintiff had stated, quote, that he could stand the risk of death because he couldn't stand to live with his existing condition, but would not have run the risk of being totally paralyzed, end of quote. Well, he didn't quite say that in the judgment. I point out that he was asked whether he would, had he known of the risk of paralysis, whether he would have consented, and he said no. But in Rival and Hughes, Chief Justice Laskin went to some extent to point out that of course you would expect the plaintiff after the fact to say that. And that's why you have to be careful of whether the test should be the subjective one or the objective one. And it was partly for that reason that the court chose the objective one, because if you had the subjective test as the test, there would always be liability, because what plaintiff wouldn't say after the fact, after the culminating disaster, that had I known about this, I wouldn't have consented to the procedure. So it is a factor you take into consideration. You must take into consideration what the plaintiff himself or herself says about his or her state of mind, but you have to look at all the circumstances. Look at the threat of doing nothing to the occupation, to the job and the income of the plaintiff, to the threat presented by the condition which caused him to go to the doctor in the first place. Weigh all of those things, and only one of them is his statement after the fact that he wouldn't have agreed had he known, and still come to a decision. So I don't think it necessarily would have affected the decision in my case, because I came to the conclusion after seeing the plaintiff and listening to him and having every sympathy for him and hearing his wife, I had no other view than that he would have done anything his doctors advised him to do. He had complete confidence and trust in his doctors, even though he had never used them before. He had been a healthy man up until that time, which was one aspect of the huge tragedy of that case.
Thank you, Horace. Following up on this duty to disclose, Barry, I've had people ask me questions going around talking about this subject, which I've been very interested in since the Rival and Hughes case. And this whole question of communication between doctors and patients is a complex one. And one of the things I wanted to ask you about is, does it need to be a direct communication between the surgeon, if it's the surgeon, and the patient, Or can this communication take place through other people? For example, the nurses, I think, are very anxious to get involved in expanding their own professional role in all of these things, and some of them feel that they can perform a valuable function in helping the patient understand what's going on. And some of them, I know, in some hospitals have actually developed little pamphlets containing information that they give to the patients. That's the one side, the people who can do the communicating. The other side is it sufficient, rather than telling the patient himself or herself, to tell the relatives about the risks? I mean, it's easy, obviously, if the person is very, very ill or the person is a child or something like that, but can one work through the relatives and the people that are close to the patient in order to achieve full information and then to receive back a proper consent in order to avoid the responsibility for failing to disclose? I don't know if you've thought about those questions.
I haven't thought about the second, I've thought about the first, and on the first question, it seems to me that it really matters not who it is that's identifying the risk or the risks that are attendant, so long as that information is imparted to the individual. I know, for example, more particularly in the dental area, where you have the high-risk situation in an oral surgery practice, it's become the mode in the last few years to, when a patient initially presents, provide that patient with written material that is fairly extensive. Not every practice does this, but several do, as to what that patient can anticipate in the event a particular procedure is undertaken. And then it's not untypical for that to be reviewed at least twice, once by an auxiliary and once by the professional himself, before he enters upon the procedure in question. So I think what's happening, at least in some areas, is a greater awareness of the need to address it and to utilize written material, auxiliaries, whatever, to make the message, to get the message across, and that's being done.
It seems that one can organize part of the team of providing medical service to provide others to give information and to use mechanisms to do so. I don't know how widespread that is. Do you know anything about that, Horace?
It's very widespread. You've heard in the introductory remarks that I have had occasion to lecture to doctors and medical students, and though I know as a matter of law, it doesn't matter how the information is communicated or who communicates the information. What does matter is whether the patient is informed. So if in the final analysis, the patient had all the information he or she should have had, how it came to him or her is a matter of indifference. And in fact, in my recent decision, I quote Mr. Justice Linden to that effect in a case that he decided. The question is, was the person informed? And the responsibility doesn't have to lie in any particular person or kind of professional. Notwithstanding that, because of policy reasons, I tell doctors and medical students that it's your responsibility, because they have too often, it seems to me, a view that this is a mere formality being insisted upon by our administrators, the getting of the written consent. So let the nurses look after that. And that reflects a misunderstanding of the true purpose of the need for informed consent, to use the shorthand. And so I tell them that you can't do that, because you don't know how someone else is going to communicate it, and you must communicate it. But I agree that that's not necessary in law. If in fact the information is communicated, that the doctor that the surgeon who performs the surgery hasn't done it is a matter of that's totally irrelevant.
Is it a particular problem with the surgeon as a genus? I have the sense that they're not talkers, the surgeons. Is that a wrong thing? I mean, if you go to a psychiatrist or to a general practitioner or to a gynecologist, I have a sense that they maybe talk to their patients more, but the surgeons they seem to be cutters rather than talkers. Is that an erroneous impression, and it may be that they could really use more, the subsidiary people and forms and that, to do the work that they might do.
Well, part of the problem is, of course, our highly specialized system of healthcare. Most surgeons are really not the patient's doctor. They're referred to that surgeon. The surgeon has never seen the patient before, in most cases, doesn't know the patient that well, and spends very little time with the patient. And it may be that if you were to compare the amount of discussion on the part of a surgeon with that on the part of a physician, you'd be comparing apples and oranges. That's because the relationship is different, and the knowledge of the patient by the professional person is different. And it may well be. I have a sneaking suspicion that there is a distinction between surgeons and between the personalities of surgeons and physicians, and that surgeons are doers, and physicians are more inclined to think. I don't mean to denigrate surgeons. Very high on surgeons, but I think generally speaking, they're men of action or women of action, and are not as likely to engage in long philosophical and patient-oriented discussion as physicians.
I think the second part of that question is very interesting, because after a few of these more recent cases on liability of doctors and surgeons, the medical people did sort of rise up a bit in wrath, and indeed I think their perception was that the courts were much, much harder on the medical profession than they were on the legal profession in these negligence suits. But quite a number of them that I know well, were concerned, genuinely concerned about the fact that it may not be in the interests of the patient to tell them all the horrendous possibilities that could arise from the treatment that they're about to undergo. There's a real problem in this, and we are totally hung up on the scope of the legal duty and how the medical people can protect themselves from liability by making disclosure, but there's a different dimension to their relationship to the patient, which has to do with the question, is it good for a patient, medically and psychologically, to tell him that he's exposed to potential strokes, paralysis, death, and so on the eve of undergoing surgery? I think this is a real problem, and this is where I guess you can't look at this problem solely from a legal perspective. And I guess this is one of the problems that we have. But the suggestion that you might discharge this responsibility by making these disclosures to a close relative rather appeals to me as solving this particular problem.
You raise the possibility of an action against the doctor rather than for disclosing too little, but for disclosing too much. He says, I've got a chart here, ma'am, we'll slice you here and hack you here, and then we'll pull this out and do that, and there'll be a lot of bleeding and you may die. And the person runs screaming out of the doctor's office and doesn't get the surgery that they ought to have.
I think we've really scared the medical profession. We've scared them in this area with this business about the disclosure they must make in order to protect themselves. We've scared them in the other area of going to the assistance of someone who's lying injured on the highway in case they get involved and incur liability. I think the medical people are a very unhappy group right at the moment, and it's a matter that we should all be very concerned about.
I think they're perhaps a little more in disbelief sometimes than unhappy, because when I've come to talk to, particularly in the dental field, at various organizations, you start by saying you've performed a particular surgical procedure without fault and without error, and everything you've done has been absolutely perfect. but you forgot to tell the patient at the beginning that he might suffer some loss of sensation or whatever as a result, and that immediately gets their attention. Then when they start to have an understanding of what it is you're really talking about in law, then inevitably you get the question, well, are you saying that every time I administer a local anesthetic in the mouth where I could, on an incidence of 1 out of every 3,000, interfere with a nerve that is going to cause a paralysis in the mouth, that I have to identify that risk, or that individual may suffer an anaphylactic reaction and die? Do I have to identify that risk? That's 1 in every 10,000, or whatever the numbers are. And you try to tell them that, well, it doesn't seem that you have to, but maybe you do, because the question as to incidence is relevant and the courts are looking at it that way. I'm not so sure that they're now so upset as they are, firstly, in a little bit of disbelief, and secondly, they're aware. And I'm not sure that's wrong either. It'll
So
shake
of course,
out
it's a
the end.
serious question, but again, you still, when you look at that Canadian Medical Protective Association and the fees, every doctor across the country pays the same, what is it now, $350, and I think it's probably the best value remaining in this country that anybody can buy, and you know, there doesn't seem to be a crisis of major proportion. Of course, it's a professional thing. It's a question of pride. It's not really money damages that bothers them. It's external supervision of their work, I guess, by people who don't really understand and don't really know very much.
I'm not quarreling with the suggestion that they're concerned. I'm not happy that lawyers believe that there is reason for their concern, because after all, what all of this reflects is a fundamental proposition in the law, which is not only in the law, but is a view of the kind of society we live in, of the integrity of the individual. And it's not satisfactory to say that the doctor has the best interests of the patients at heart, and therefore let it be up to him or her to decide what he tells them. It's still a relationship with a human being who has rights, and those rights must be reflected in the law. Let me give you an illustration of how concerned some doctors are. There was an expert witness in the case before me, and he was a really impressive expert witness. I would identify him if I told you what his specialty is, so I won't. But he is at the top of his field in Canada, worldwide perhaps, not just in Canada. And in cross-examination, on the question of what the practice is, of what his practice is and what the right practice is with respect to informing patients, it was suggested to him that the College of Physicians and Surgeons of Ontario had recently sent out a circular reminding doctors what their obligations were, and that circular summarized the points made in Rachlin Hughes. Every doctor in Ontario got one, and he was cross-examined about it and indicated that he didn't even know what the cross-examining counsel was talking about. He wasn't familiar with the document. Well, aren't you a member? Of course. But when I get things like that from the college, I throw them in the wastebasket. Well, I don't know how typical he is, but that worries me. I think these things are intended to explain something to people who should have things explained to them. And it's not intended in any way to impugn their own professional integrity, but it is intended to strengthen the concept of the integrity of the individual with whom they are in contact professionally. So I'm not sure that their concern. In Canada, I think the medical profession in the United States has a legitimate reason for being concerned about what lawyers do and what the courts do. But I don't think, objectively, the courts and the legal profession in Canada can be criticized for what they have imposed by way of more than ethical requirements on physicians.
I was interested. I had a new experience as recently as last week. I paid my first visit to a dentist in Ottawa and was handed a small document which in effect was an exculpatory clause. So I suggested to him perhaps he ought to talk to his lawyer and get some advice before he started just handing those out to every patient who was coming in for a filling. But I think it is a manifestation of a general concern.
But if you had talked to your lawyer, he or she would have told you, don't read it. Don't make the mistake of reading it.
Bertha, you hinted earlier your questioning of the validity of some of these exculpatory clauses. I didn't realize I've been pronouncing this word wrong. I don't want to say exculpatory, but I guess it's exculpatory.
Optional.
What is one? Is one British or American or Scottish or? But what kind of legal theory would one use? You said it would be a target. What type of legal theory would one use to attack those exculpatory clauses? We of course already have this contra proferentem rule as terms of narrowing it and whether it's come to the notice of the person. But if one were to take it head on, what type of rationale would one employ?
Well, I think that the rationale would be the one that I believe has been followed in some jurisdictions in the United States, namely that if a person is a professional person holding himself out as having a reasonable degree of skill in a certain area, he should not be permitted to limit his liability or relieve himself of liability for negligence on the basis that it's contrary to public policy to do so. Here is someone who's representing to the public that he has this level of expertise, holding himself out in that regard, and then for him to exculpate himself and have the very person who has responded to this representation to insert such a provision is really contrary to public policy. And I believe that a number of these clauses have been struck down and that there are statutory provisions in some jurisdictions in the States saying that clauses which purport to relieve a professional person exercising his professional calling, purporting to relieve him from liability for negligence, is just contrary to public policy and shouldn't be permitted.
In Ontario, as a matter of fact, the Solicitors Act, in its current revision in Section 24, says, a provision in any such agreement, that's a retainer, that the solicitor is not to be liable for negligence, or that he is to be relieved from any responsibility to which he would otherwise be subject as such solicitor, is wholly void.
Yes.
That's a direct attack.
Coming.
Barry, do you have anything to comment about this?
Just an oversimplification. It seems to me that it has taken many, many years to move away from a contract theory to create a tort liability in respect of third parties, innocent victims. It would almost appear retrogressive if, in respect of a third party who's not a party to the contract, to then start to employ the contractual analysis on a determination as to whether liability does or does not obtain, or a duty exists relative to him. Why would you ever want to do that? But that's absent all the other considerations that you might want to bring into the hunt.
Horace, you mentioned that case about the lawyer who recommended settlement and the decision of Justice Anderson saying that it was pretty hard to demonstrate that was erroneous. But what if the lawyer failed to recommend settlement? What if the defense comes along and pays in a court $50,000 or $100,000 and the plaintiff's lawyer says, oh, no way, we're going to get $500,000, $1 million, let's go, and he loses the case? Is that the kind of thing that Gerald and DeMarco, do you think, could be employed at holding the lawyer responsible for failing to recommend settlement?
I don't think there's very much doubt about it. I think if you ask most lawyers whether or not a lawyer can be liable, if, for example, it comes up often in connection with limits on policies and exposing...
That's the insurer's failing to settle, so it applies there.
Failing to settle at the policy limit and then getting a judgment over that without communicating it to the client that there was that risk. Those problems occur frequently, and I haven't any doubt that in the proper kind of case, there is a duty on a solicitor to convey to his client that an offer to settle has been made, and if he fails, if he's in breach of that duty, with resulting harm, I don't think there's any doubt that, again, in the proper circumstances, the court might hold there was negligence. The lawyer is responsible for the difference.
Did you see Paul Newman in the verdict?
Yeah.
Yes.
If it had gone the other way, he would have been liable not only civilly, but also for subject to disbarment, I suppose, for failing to communicate the,
Yes.
the thing. We have this awful long, complicated question. It's really not the kind of thing to tackle, I don't think, in this way. Does anybody have anything they'd like to raise from the floor? Short, sharp, simple questions, or are you getting so exhausted you want to get moving on? What do you think? Thank you. Okay. Thank you very much.